Next section is Goodbye Gun Shows. There's an editor's note. The next chapter is Neal Knox's earliest published writing on the Dodd Bill, which eventually became the Gun Control Act of 1968. As it proves, he was paying attention to legislative matters when few gave a second thought to such things. Even more significantly, he recognized the danger that lurks in legislation that enables bureaucracy to create regulations that wield the full force of law. This piece examines how a change in the interpretation of a regulation could affect the firearms community. Guns Magazine editor E.B. Mann considered the piece important enough to kill another story to open space. Examining the original copy, it is apparent that the piece was rushed. It included a typo or two. That's understandable. With a cover date of July 1966, it was likely on the newsstand in mid-June. Yet the second paragraph refers to a letter dated March 9th, 1966. 6 months is a typical lead time for a monthly magazine in the high-speed, always-on 21st century. Yet in a day when pasting up a magazine meant exactly that, gluing strips of copy-laden paper onto a storyboard, this article went from Knox' antique Underwood typewriter to published print in less than 12 weeks. Knox and the Guns staff put forth a valiant effort to strangle a monster in its crib. They may have stalled it, but events would turn against them. Just less than 2 years later, the assassinations of Martin Luther King and Robert Kennedy would change a few votes in a narrowly divided Congress. Neither assassination would have been affected by the new law, but Congress felt the need to do something. 3 years after the Dodd Bill was signed into law, in essentially the same form as Knox describes here, agents of the Alcohol, Tobacco, and Firearms Division of the Treasury Department, which would soon morph into the Bureau of Alcohol, Tobacco, and Firearms, kicked in Kenyon Ballieu's door in search of non-existent illegal explosives. In the melee that followed, Ballieu was shot in the head, surviving, but just barely, with brain damage that wrecked his life. That disaster was the first of a long chain of Gestapo-like raids, sieges, and questionable arrests, the most infamous being the horrific raids against the Branch Davidians, a cult with apocalyptic visions in the Texas plains. Read through the smoke and haze of these debacles, the closing words of this article seem eerily prophetic. It's dated July 1966, Gun Magazines. A federal agency acting under provisions of an anti-crime law has launched a move that may be the death knell of organized gun shows, the lifeblood of antique arms collecting. The unprecedented move made by legal regulations under the Federal Firearms Act comes at a time when Senator Thomas Dodd and key administration officials are assuring the press and public that the broad regulatory powers of S 1592 would not and could not be abused. On March 1969, in March 9th, 1966, President Johnson sent a message to Congress which called for greater controls upon firearms and passage of S 1592, Senator Dodd's bill, but stated there is no need to curtail the right of citizens to keep arms for such traditional pastimes as hunting and marksmanship. The very same day, Billy L. Gaunt, Dallas chief of the enforcement branch of Alcohol and Tobacco Tax Division of the Treasury Department, sent a letter to Robert M. Riley of Baton Rouge, Louisiana, indicating plans to enforce a regulation that would definitely curtail the traditional pastime of antique gun collecting. The letter requested that the special investigator in charge of the New Orleans Alcohol, Tobacco Treasury unit be allowed to address the March 12 and 13 Baton Rouge gun show and advise exhibitors of the provisions of the Federal Firearms Act, distribute the regulations, and offer any necessary assistance. The next paragraph has sent a chill through every collector that has seen the letter. This is in quotes, it has come to my attention that while primary purpose of past gun shows was to exhibit antique weapon collections and new items for customer surveys, often firearms are traded and sold. The majority of exhibitors are firearms dealers licensed under the Federal Firearms Act. Federal law prohibits persons licensed under the Act to conduct the business of selling firearms at any location other than that shown on their licenses. Violations could result in criminal prosecution, along with the seizure and forfeiture of weapons involved. That's the end of the quote. Men who were at the show said not only Gaunt, but several other federal agents attended the meeting, and there wasn't a gun traded. Swapping and selling has been traditional at gun shows and is one of the major reasons for their existence, just as with coin and stamp collector shows. A collector or dealer collector, if he wishes to look at guns, can visit museums, but if he wants to improve his collection, eliminate duplicates, or move into another collecting field, the place to go is a show. Dealers from a wide area gather to display their stocks of guns, most of which have not been fired for half a century or more. A few guns are sold, but most exchanges are trades, and it isn't unusual for a single gun to be involved in half a dozen swaps during the course of a day's tall tale telling and gun talk. The debates over the values of old powder burners, even the most determined of the anti-gun crowd would have a hard time finding anything resembling a crime or criminal-type guns, unless it were the guns of criminals of an earlier era. Chief Gaunt or his agents weren't expecting to find hoodlums or thugs among the doctors, lawyers, ministers, and businessmen who attend, exhibit, and swap guns at a typical show. Chief Gaunt expected his men to do their job by ending violations of the clearly stated federal regulations. He isn't precisely correct when he mentioned that federal law prohibits such sales, for what he is referring to is the federal regulation devised by the Secretary of the Treasury, but the effect is the same. And it made no difference that the law had never been enforced that way during the years that it has been in existence. It made no difference that the regulation was designed to halt crime and not legitimate activities. For an officer of the law must uphold the letter of the law. It is not up to him to determine the rightness or wrongness, whether the lawmakers intended for such activities to be ended. His job is to enforce the law. Whether Chief Gaunt received instructions from higher authority or learned of the activity and moved under his own authority is immaterial. But some people in Washington are going to be distressed when they hear of this action, for it emphasizes the validity of the pro-gun arguments against broad regulatory authority being granted to federal agencies. Chief Gaunt's authority is included in Part 177 of Title 26, Code of Federal Regulations, Interstate Traffic in Firearms and Ammunition, Federal Firearms Act, Section 177.33 states, and this is a quote, "The license applies to the operations of the licensee at a specific location. Accordingly, a separate license must be obtained for each place at which the business of importing, manufacturing, selling, or distributing firearms or ammunition is conducted." End of the quote. Since selling an antique gun is an operation of the licensee, this regulation clearly applies. The regulation is not a new one. It has existed in its form since 1957 and may have been stated the same way most of the 28 years since that Federal Firearms Act has been on the books. But the stipulation that a dealer cannot sell or trade a gun anywhere except at his place of business is not included in the Federal Firearms Act. That aspect of the Act is a matter of regulation produced by the Treasury Department, not created by Congress. Application for a variation from the regulations to allow dealer sales away from their primary place of business must be submitted in triplicate to the Assistant Regional Commissioner, who will forward it to the Director. What the Director's pleasure will be won't be known until the dealers in antique arms submit requests to sell at shows. Dealers may have obtained special permission in the past, but few, if any, have requested it, for the regulations have never been enforced. This is the situation as it now exists. What would be the effect if Senator Dodd's administration-backed S-1592 became law? There are 7 sections in the proposed bill that give it regulatory powers to the Secretary of the Treasury. Some can be considered necessary for national administration, but others, written in such a way to give discretion to the Secretary in matters that should be decided by the Congress, where the people are represented. Dealers would be granted a license if the Secretary were satisfied that he had enough business experience, was of good financial standing, and he had good trade connections. This writer has known quite a few successful gun dealers without prior business experience, but few that had many extra dollars in the bank or had good trade contacts before they entered the business. How much business experience, money, and trade contacts would the Secretary require before allowing a gun buff to go into the business? If a dealer or individual wanted to import a gun, the Secretary may authorize it if he were satisfied that the gun were to be used for scientific research, were an antique, or of a type or quality generally recognized and particularly suited for lawful sorting purposes, and is not a surplus military weapon, and that the importation or bringing in of the firearm would not be contrary to the public interest. What is an antique? Are surplus models 98 Mausers actions such as have been the basis for many fine sporting rifles, totally excluded by the bill? What, pray tell, is the public interest? And if the public doesn't agree with the Secretary's definition of public interest, what can be done about it? If the law were to forbid interstate shipment of firearms except to dealers, and the Secretary of the Treasury could so easily refuse to grant a dealer's license, where would we buy guns? If the regulations concerning purchase of a firearm become too bothersome for the beginner to contend with, from where would the next generation of gun buffs come from? On April 9th, 1965, a letter from the National Rifle Association to the membership stated, concerning S-1592, this bill, if enacted, would give the Secretary of the Treasury or his delegate unlimited powers to surround all sales of guns by dealers with arbitrary and burdensome regulations and restrictions. The Treasury Department, in an analysis of that letter, scoffed, "If a regulation were outside the statutory standards established by Congress for the Secretary's actions, or if it were not reasonably necessary to carry out the provisions of the statute, or if it were unreasonably burdensome, or if it were regularly issued, it would be declared invalid by the courts." Senator Dodd and the Treasury Department have cited the Administrative Procedure Act, which requires an agency to hold hearings before establishing regulations, and have declared many times the Secretary could not exceed the scope of the law. But this law gives such wide scope that any possibilities mentioned in this article could conceivably become part of the regulations and could be determined reasonable by some judges. Senator Dodd calls his bill an anti-crime bill. The Federal Firearms Act was supposed to be an anti-crime bill, but can any reasonable person contend that a dealer selling a firearm at a gun show has anything whatsoever to do with crime? Senator Dodd has cited the record of Treasury Department for its reasonable regulation and enforcement of the Federal Firearms Act. Although some of the gun clan don't think this record is spotless, but at the height of the struggle concerning the passage of a far more restrictive bill, the ANTTU, Alcohol and Tobacco Treasury Unit, has taken steps which could conceivably eliminate a traditional gun pastime, nearly 30 years after the law became effective. An authority on the passage and administration of laws once said, "You do not examine legislation in the light of the benefits it will convey if properly administered, but in the light of the wrongs it would do and the harms it could cause if improperly administered." The gun collections and shooters hope that the President and Congress will consider and heed these words of Lyndon B. Johnson.
The guys and gals of GunWebsites.com encourage you to take a CCW class every year, practice at least once a month, and carry every day. Thanks for watching GunWebsites.com.